Michael, welcome back to the show. How's it going? What's new?
It's
What's
going
happening?
great. Good seeing you, Carrie. How you
You
been?
too. Pretty good. Pretty good. Geared up for the holidays. I know people won't be listening to this until 2025, the first week of 2025, but we are here on the brink.
Yeah, it's busy. So busy. Having kids the ages that we have, it's so busy.
What's the Santa situation for you guys? Are you still deep in belief in terms of your
Yeah, you know
kids? And
what?
like, does one kid know and the rest don't? You kind of
Great,
gotta keep secret.
great question. So we got one in limbo. So we've got one that is totally knows and helps us with lots of things. That's our 13-year-old. Our 11, she's in 5th grade. There's lots of conversations at school right now about if, they want to keep the magic, but like they're hearing whispers of their parents said it's not real. And so like I think by the end of this year, that's over. That game is played. And then my youngest daughter, who is 9, 3rd grade, she's like full blown, like Elf on the Shelf, Santa, the whole thing. So yeah, my 5th grader, she's helping us with Elf on the Shelf right now. She learned that that's something that parents do. So we'll see. I bet December 26th, cat's out of the bag, and it's over for next year.
My kids are 9. I'm in the same boat. They are full on belief. And I was like, when's the shoe gonna drop? Like,
Yeah, it's so sad that it happens. It usually happens at school. It's someone they talk about it, whatever. But it's
I
fun.
know. I'm dreading the day. I'm
Yeah.
dreading the day. I mean, we have easy proof of just showing them our Amazon lists, but I'm gonna keep the dream alive. My husband is actually out right now buying an Elf on the Shelf because we're worried this might be the last year of the magic, and we've been sort of holding off
Got it.
the Elf on the Shelf, but we feel like if we're gonna do it, it is now or never. So
Yeah. Now's the time. Now's the
we're
time.
going in. We're going all in. Awesome. Well, I'm excited for our show today. I have a lot of questions around once you have an estate plan, then what?
Yeah.
What
You
happens?
know what?
So
It's such a good question. It's such a good question. No one ever talks about that. Like, we sign some documents and then what happens, right? Like, what do I hold on to as the client? Like, where are my documents? Just, are they in the cloud? Do I keep a physical copy? So good question. Maybe I start there with like, you sign documents, you're in the office doing it or virtually or whatever, and then what happens?
yeah.
So I would say most estate planners are going to provide you with a binder of some sort that holds your documents, some way to keep them organized. But most times the clients hold the originals and the law firm is going to, keep a digital copy, keep a backup copy in the event that something happens. So usually the client is going to hold the originals if you do a full estate plan, will, trust, powers of attorney. There was a historical practice of law firms would hold on to wills because wills have to be probated. They would kind of hold on to those so that once someone passes, they have the copy so that they can submit it to the probate court. But if you're doing full-blown trust planning, you're going to have all the originals typically. Does that make sense?
It does. And if I remember, I've seen the binders being passed around. I mean, they are no joke in terms of how big they are.
Yeah,
Is that pretty standard?
I would say you're looking at,
Yeah.
if you're doing a full plan, you're looking at somewhere on a couple hundred pages. A trust is going to be anywhere between 50 and 100, depending on the complexity and what kind you do. Then you got about 20 pages per other document. So yeah, you might even be upwards of 300 pages. So yeah, I mean, you're looking at a good stack of documents. Being that you have the originals, you're going to, be mindful of where you're keeping this. Our recommendation is typically keep it somewhere safe where someone knows where it's located. So even if it's just the top shelf of your closet, that's absolutely fine. I kind of recommend against like a safety deposit box at a bank because you never know if an emergency might happen outside of business hours. Or if it's going to be in a fire waterproof safe, sometimes clients like to do that. Someone's got to know how to get in the safe. Like, where's the key? What's the combination? So somewhere safe where someone knows where it's located is really important. Does that make sense? So you're going to have
It does make sense.
Yeah.
Yeah. You never know when you're going to need this thing, unfortunately. In terms of copies, do you make copies? Is there one to rule them all? What's sort of the deal?
I mean, you have the original. It's kind of client driven of how many copies we make. We typically just give the clients the originals plus the PDF electronic versions that they can distribute as they want to. My worry is we don't want a bunch of copies of this thing floating around out there, because as you make changes, you got to remember who's all got copies to give them the changes. So,
Yeah.
that, and it's the same reason why we only give banks a document called a certificate of trust versus the full trust, because then every time we make a change, we got to provide, the full copy. So that's at the client's discretion as to what copies they're provided. What I'd rather do and prefer is have their kids involved, or whoever's important in their life involved in the signing meeting, to like go over all of this so that we're all on the same page. I love that stuff. But yeah, as far as copy goes, that's just kind of client preference as far as, who's going to have a copy. And a lot of times just providing the name of the law firm they're working with can be very helpful, so that if something happens, they can reach out.
I think it's good to know what best practice is. So having one original copy and then some copies as a PDF that on a like a thumb drive that you can hand out, I think is great. In terms of getting it updated, how often, what's the ideal age of when you do this thing? And
Yeah.
then assuming it's like 35, 40 when you're married and have kids, but then how often should you get that updated?
Yeah. Lots of pieces to unpack there, but you should, as soon as you become an adult, you really should have something, even if it's just powers of attorney in place. But let's just talk about, when do most people do estate planning? It's usually when they start having kids. So when you start having kids, you're like, okay, what are the boxes that I need to be checking now that I'm adulting? And one of those things is usually some estate plan that puts in place, who's going to be the parents of my kids in the event that I can't be. That's the guardian. So some legal document that says who's going to be the guardian. And then a lot of times it's just a very simple form of a trust that says, hey, if I pass away early, I want to stagger the distribution and have it be available to them for the things that I would have provided had I been alive. And usually that's funded by life insurance, because most of us, when we're having kids, we don't have much. So usually a good life insurance policy, simple trust in place, and then a guardianship appointment of who's going to be the parents of my kids. Does that make sense? So that's the age of when we start doing this. And then your maybe fifth question in all of that was, how often should we update this?
Mhm.
And there's some kind of rule of thumb out there that I've heard people say a lot, like every 3 to 5 years, have it reviewed. I would say there's no law changes that typically happen within every couple of years to require changes. More so, we're looking at what has changed in your life that might require a change to your plan. Things like, have you had any more kids? Have you moved? And so more so, when we look at an update of a plan, we're doing like a funding check. Are your assets all still the same they were 3 to 5 years ago when we originally did the plan? Is everything still funded into the trust so that this is going to work when we get, to that point where we're needing it? Another thing to really consider is financial institutions, hospitals, they really want these powers of attorney to be like no more than 5 years old. There's no rule that supports that. There's no law. There's no nothing. It's just internal policies at banks, hospitals, investment, places. They all want these financial and medical powers of attorney, just kind of like 3 to 5 years old is kind of the golden rule there. So as we're meeting with clients and maybe they were talking about some other life changes, if nothing's changed in their powers of attorney, we might just print off new ones with new dates and have them sign them. Does that make sense? Just so that when
Yeah.
there's new dates on them, keep them fresh. Yeah, of course, if there's been any updates in the law, we're going to make those quick changes. But for the most part, we're just getting those new dates on it can be super helpful for the family.
So I'm hearing, just to recap, I'm hearing two things. One is triggers. So if anything major changes in your life, you might want to consider getting this updated, whether that's more kids, whether that's you're moving, whether that's maybe something happened to one of your powers of attorney, making that immediate change. And then on the flip side, just having it from a powers of attorney standpoint, making sure that that paperwork is within range every
Yeah.
few years.
Yeah, I would say a very realistic timeline, if we were to walk this through our life, and I've never done this out loud before, but I'll do it with you real quick, and I think this makes a ton of sense. Most people put in place an estate plan when they first have kids. Then from then until the kids become able to be appointed in the documents, so they're 18, 21, 25, whenever they hit, they're mature enough. They have to be at least 18, but usually they're not mature enough till their mid-20s and beyond. So that's really when we're making our first changes to the plan, is when the kids are adults, to like, let's start looping them into these documents, make them our backup agents, successor trustees, those kinds of things. But along the way, every 3 to 5 years, it's good to just have a quick check-in with your estate planning attorney. Just, okay, let's see if we're still properly funded, if we've changed jobs, is the new, employer managed 401k in there. So like every 3 to 5 years, it's great to just do like a funding check. But I would say the plan gets started when you have kids. It gets its first real update once the kids are 18 or older, once they can be looped in. And then we're continuing down that same path of like every 3 to 5 years, let's make sure our assets are still in there, maybe some subtle changes, until you're getting on towards the age of retirement, that's when people start looking at other kinds of trusts, like asset protection trusts, so that in the event they need long-term care, that's covered. That seems like a pretty common path forward for most people. Now, there's going to be some other changes. A windfall of some wealth, an inheritance from a parent or something could change things where we need to do some tax planning or something like that. But for the most part, I think that's a pretty fair assessment. Is you do the plan when you have kids, you check in on it every 3 to 5 years. Your first real update is going to be once your kids are going to be involved in the plan. And then your next real huge update is once you're nearing retirement and we're planning for different things.
Okay.
Never said that out loud before.
Yeah, no, that is totally logical. It makes a ton of sense. And I think that really puts in perspective of people of like, don't feel like you have to wait to have this thing until you're, more in that retirement age. It's good to have it now. And then here's what that could look like in terms of keeping it up to date and some of the things that go into it. Is there anything I missed in regards to what people should know, like once you have this thing, what you should do with it?
Oh yeah, some good things are like, you're gonna want to put it on file with like your nearest hospital, right? And so as you're so back to, we've signed the plan, now what? As you have doctor's appointments and hospital visits for whatever reason, make sure you're putting your healthcare power of attorney on file. You typically get asked for it. That's actually a big triggering event of why people come see us, because they've had 30 doctor appointments and every single time they're like, do you have a healthcare power of attorney? Do you have a healthcare power of attorney? Do you have a healthcare power of attorney? They're like, well, maybe I should probably get one of those.
I should get this thing.
So typically providing it to your primary care doctor puts it in the system or the network of which your primary care is part of. And that usually gets it in the hospital system too. But it's great to like, if you're there, provide a copy, put it on your file. That way it's on file. Same thing goes with, for funding, with our law firm, you're going to take the next step and work with us to get all your assets in the trust. But if you weren't working with us and you're listening to this, either you're going to end up doing the legwork, or you can employ my other company, trustfunding.com. That's cool. Love that. They'll plug there. But you're going to sign your plan, and then you got to get all your assets into the trust. That is imperative, or else none of this is going to work. So you're going to be doing that kind of for the next couple months.
That's a huge misstep often, isn't it? Where like everybody thinks the estate plan is done, but there's nothing actually in the trust.
Yep. 90+% of people don't fund their trust properly. It's why. Most attorneys will do all the fantastic legal work. They'll put it together, great documents for you that say what's going to happen and when you pass and all of that. But then they say, okay, now my job is done. Clients, you need to go to all your banks and institutions and fund your trust, meaning change beneficiary designations, retitle accounts. It all depends on what style of trust you have as to like what the next steps are for that.
Gosh, that sounds daunting.
What
happens if you don't have anything in the trust? Then it's worthless? It's useless?
It becomes a very expensive will. So it ends up, everything goes through probate. You can submit the trust as evidence of what your wishes were. A lot of times you have something called a pour over will, which says that if I pass away with assets in my name personally, they go over to the trust, but it takes the probate process to get them into the trust. to divide according to the trust plan. So back to what I originally said, it's just a very expensive will. Yeah.
I think the whole point of this process is to avoid probate at all costs. So
It's usually why families are typically calling initially, is they want to, they have some personal experience with the probate process and they're like, I never want to do that. So how can I avoid that? And we, do that by setting this all up. But unless you properly fund the trust, it's not going to work.
I might be opening a can of worms here into a entirely new show. And if that's the case, then, we'll sprinkle the dust here of breadcrumbs towards the next one.
Okay.
But what if you're on the end of something happened to a family member and then you have to take the estate then what do you do as the beneficiary with it? Like,
Yeah.
then what?
You just we're going to do 3 shows on that. We're going to do 3 shows. Yes.
Okay, let's lay them out. What are the 3 shows?
Yeah. So what you're talking about is trust administration. So now, essentially we just talked for the last 20 minutes or so on you sign the plan. Now what? Now this is okay, I've passed away. Now what? Like the person the grantor, which is just, remember, a fancy name for who created the trust. When that person passes, there's usually a section in the trust called administration after the grantor passes or dies. And after the death of the grantor. And so now what do I need to do? And this is all things like consolidating assets and, getting everything into a trust account, looking at the residual distributions, see, when am I able to pay those out? There's a notice to creditors period. There's a whole thing on trust administration.
Great. I'm taking notes.
Yeah. It is relatively straightforward. There's just a methodical process to do it.
Yeah.
And
I think it would be really helpful for people to know what that is. And I think it would be good to compare it to what happens if you don't have it and what the probate process might look like versus this. We might actually already have a show on that, but I'll go look. If we don't, we'll make sure you have both.
That would be a good one. Yeah, because it's important. I mean, most families their family will have a meeting with us. We'll walk them through what needs to be done and they can tackle it themselves. I would say 10% of families hire us, but not because of the complexity of trust administration, but more so because they just don't have the time to do it.
They just want to, there's other matters at hand than admin work, as we know. I'm so grateful for this conversation, Michael. Thank you for taking me on that journey, and to all of our listeners. We got 2 weeks here before we reconnect, and the holidays brewing. What's one thing you are most looking forward to at the end of the year?
Downtime. Just it's great to have everyone, like across the board, everyone slows down a little bit. And I'm just really looking forward to that.
Same. Right there with you. Right there with you. Well, I'm so grateful. Thank you so much. I'll see you next time.
All right, Carrie. Great seeing you.